Hi, my name is Bruce Hammer. I'm the managing broker at KW SAC Metro and KW Capital Valley. And this is a class, a recorded version on the residential listing agreement. So to start off with, if you guys are using your WinForms or ZipForms subscription, you will find that if you choose a listing agreement in your WinForms library, when you go to actually start using it, it will actually add your agency disclosure, your wire fraud disclosure, your fair housing addendum, all sorts of other paperwork up ahead of the actual listing agreement. But these other documents, even though they are general forms that cover other things, they are an important part of the actual listing agreement. So we're going to cover those briefly first. You can see up on your screen, you should have the first document, which is the first page of the disclosure regarding real estate agency relationships. I've highlighted a few things here or underlined a few things here for your benefit, but I want to point these out to you. So California law, specifically the Civil Code, requires agents to disclose what types of agency they can have with their clients, whether it's the seller or the buyer or both. This first document, the first page of it, which we're looking at now, covers the explanation of the different types of agency. The second page that we'll get to in a second is basically the Civil Code legalese version of what you're seeing here. And it gives a few definitions too. So looking here, we see that the first type of agency that's described here is a seller's agent. You may recall from real estate school, agency describes a fiduciary relationship. So what does that mean? Well, as it says here, to the seller, a fiduciary duty of utmost care, integrity, honesty, and loyalty in the dealings with the seller. Pretty simple, right? You can't do any self-dealing. You have to work for the benefit of the seller. What that really means is you have a duty. You owe the seller a duty to get that seller's property sold under for the highest price and the most favorable terms that you can get for that seller, irregardless or regardless of your interest in getting it sold so you can get paid a commission. That should not be part of this calculation. So part of that is when you're listing a house for a seller, do your due diligence for them. Make sure you run a comparative market analysis so you can see and you can show the seller that the price that you're recommending as the fair market value or the list price is in line with the comps that are in the area. Don't do what some of those agents do. They get what I call commission breath, and they underlist the property to get a quick sale. That is not working in the seller's best interest. Okay, so seller's interest or seller's duty is to get that seller into the property. The seller's duty or the seller's agent's duty is to get the highest price for the property. Now, if you look here, it talks about owing a duty to the buyer and the seller's agent, that is. Well, what does that mean? Here it says, amongst other things, a duty to disclose all facts known to the agent that materially affect the value or desirability of the property that are not known to or within the diligent attention and observation of the parties. It also talks about a duty of honest and fair dealing and good faith. Well, this duty is owed to the buyer and seller. And if you look down under the buyer's agent's duties, it has the exact same duties. So it doesn't matter whether you're representing the seller or the buyer. You actually owe the same duty of honest and fair dealings and good faith to both parties. It's kind of like that old rule, what's the golden rule? Do unto others as you have them do unto you. You need to treat every party equally and do the right thing. That's all it's saying. The buyer's agent, I already told you, the seller's agent has a duty to get the seller the most money for their property and the best terms. The buyer's agent, by the way, has the opposite duty. Well, it's a similar duty for the buyer, but it's the opposite of the seller's goals. The duty of the buyer's agent is to get the buyer into the property for the lowest price and the best terms. But keep in mind, they still owe that duty of honest and fair dealing and good faith to not just the buyer, but the agent owes it to the seller also. So just keep that in mind. Now, here's where it gets a little confusing. When you have an agent that represents both seller and buyer. And part of what gets confusing here, not only in the exercise of your duties, but the other part of this that's confusing is, when is an agent representing both seller and buyer? Pardon me. The obvious answer to that is when you as an agent list a property and then you also represent a buyer to purchase the property. That is definitely dual agency. You're representing both parties. What is a little more murky is, and what a lot of agents don't fully understand, is dual agency is not just determined by you as the agent representing both parties. It's determined by the brokerage that your license is hung under or associated with. So for example, in KW SAC Metro, we all work under the corporate license, which is 014885473. Well, if let's just say I listed this property. I'm the listing agent. I happen to be a broker. I'm the broker of record here, but I'm pretending I'm just a broker associate here. I listed this property, and one of the other 250 either salesperson or associate brokers that works at KW SAC Metro has a buyer, and they bring that buyer, who then submits an offer on this property, and the offer is accepted. Well, here's the deal. I may have never even heard of that other agent at KW SAC Metro. I mean, realistically, there's 250 of them here or so. I may never have heard of that agent. I may never have met that agent. I may not know that if I walked by that agent, down a corridor, I might not even recognize him. But because that agent's license is hung under DRE number 0148547, that transaction becomes dual agency. And that's what has to be disclosed by the buyer's agent when they write the contract. So if you're a buyer's agent, you want to be sure to look on the MLS and make sure that, it can say Keller Williams Realty and not be one of our officers, not be this office. But you need to check that before you write up the offer, because when you write up the offer as a buyer's agent, you're going to check the boxes that disclose whether you're representing just the buyer or whether you're representing both, whether it's seller's or buyer's agent, or whether it's dual agency. So check that first. Now, let's quickly contrast this scenario that I just described with a little bit of a variation. Let's just say, keep in mind, I personally am the broker of record for both Keller Williams Realty Sacramento Metro and Keller Williams Capital Valley, which is our Fair Oaks office. What about if somebody from KW SAC Metro listed a property and somebody from KW Capital Valley has a buyer who puts an offer in on this property. Is that dual agency? Well, you might be tempted to say yes, because I'm the broker of record for both, but it is not dual agency. And the reason it's not is because dual agency is determined by the corporate license number, not the broker of records license number. So again, Capital Valley has a different corporate license number than this, which means that is not dual agency. So I hope that's clear. Let's see. Oh, one important thing to also talk about here. I personally don't like dual agency. A lot of agents love it, and it's legal. A lot of agents love it because it's an opportunity, especially if you're representing both the seller and the buyer personally. It's an opportunity to double up on your commissions. I personally don't like it because it puts me under more of a microscope as to whether or not I'm doing the right thing when I advise each client. But one thing that you do definitely have to realize is when you are representing both the seller and buyer as a dual agent, without written express permission of each party, you cannot disclose to the other party any confidential information that you've gotten from them. And that includes, for example, whether or not facts related to either the buyer or seller's financial position, what's motivating them to do the sale, their bargaining position, or any other personal information that can impact the price, including the seller's willingness to accept a price that is less than the list price, or the buyer's willingness to pay a price that is greater than the list price. You really have to be on your game and make sure you don't disclose to the other side any of this confidential information, because that could put you in violation of the civil code because you violated the rules that you have to follow when it's a dual agency situation. All right. Moving on. So this is page 2, as I mentioned. This is kind of the legal version that's right out of the civil code. Normally, I don't go into this with a client, but I will tell you for your own information, there are important things on here that might give you some assistance at some point if you need it. There's an explanation of what a listing agreement means, what list price is, what an offering price is. It talks about what a seller means, and it defines what a seller's agent is, and so on and so forth. That's all that's on that page. The next page in this package is highly important. It is so important that at the end of this series, there will be a separate class just on fair housing and discrimination. And why is this important? Because California, as well as the rest of the country, does have a, for want of any other politically correct way of defining it, we have a very racist history. There's been a lot of discrimination going through the decades, going through the centuries, and under federal constitutional law, through the 14th Amendment of the United States Constitution, specifically under the due process clause. This would be under substantive due process, as well as under the California Constitution and California laws that have been passed. It is categorically illegal to discriminate against not just racial discrimination, but any number of different classes of individuals. And you can see, many of them are listed here. You can't discriminate on people based on their age, citizenship, medical condition, sex or sexual orientation, gender, gender identity, marital status, whether they're a veteran or not, familial status, source of income, all sorts of stuff. These are all different classes that you cannot discriminate against. one that I didn't mention, disability. That's a big one. So you need to be very careful because there are fair housing shoppers that will pretend to take you on as a, as their realtor, and they will try to bait you into showing either intentionally or by accident that you have violated one of these fair housing laws concerning a protected class. And if they find that, defending it is very expensive. And if you are found to have violated fair housing laws, the penalties are extreme, financial as well as loss of your license. So you need to be familiar with this stuff. As I said, I'll have a separate class on just this topic, but some of the things that you have to watch out for. And let me say too, most of us are not inherently racist or we don't inherently, try to be discriminatory. What generally happens is a mistake that's caused by ignorance, and that's what the typical violation is going to encompass. Let me tell you how that can play out. A couple of examples I've heard of. You list a home, and in your marketing comments, you put a statement, something to the effect of, because the house is pretty close to a nice, beautiful family park. You put walking distance to neighborhood family park. Well, in that sentence, you've committed potentially 2 fair housing violations. You said walking distance, which could put you or could have you run afoul of the Americans with Disabilities Act, because many people can't walk. And unfortunately, that is one of the triggers that attorneys that specialize in ADA violations will look for. Now, you say to yourself, why would somebody bring a case like that? It seems like, what attorney is going to take a case on like that? Here's the deal. For most of these fair housing violations that fall under the umbrella of a constitutional civil rights violation, that's how they're classified typically, they have built into the statute a provision that if any attorney takes on that case and the attorney prevails, they are granted reasonable attorney fees. So you have a lot of attorneys that will take these cases because they know if they can prove it in court, they're guaranteed to get their attorney's fees paid by the defendant. So that's why attorneys will take these cases. I said there was potentially 2 violations in that one statement. Neighborhood park, walking distance, or neighborhood family park is walking distance from the home. The other one is family park, family home. The term family means different things to different people, and many families are not traditional, and so by referring to something as a family-friendly neighborhood, family park, close to family park, things like that, that can also put you afoul of fair housing violations. Let's see, criminal history. So you can't just, and I'll use this in the context of property management. When you are reviewing a tenant for property management rental, you are not allowed to take into consideration their criminal history for qualification purposes. Now, oftentimes in a complex, if you get past the qualification, in other words, if you discount the criminal history, are they qualified to rent? Sure. Well, once you've made that determination, if they are qualified to rent, then the only times I've seen criminal history become relevant is when there is a homeowners association who has provisions in their rules that say if you're a landlord, you can't rent to somebody who has committed certain crimes, or who is who's on the Megan's Law list or things like that. Those are some of the things I've seen there. Sexual orientation, can't discriminate against two females who are interested in buying a house, or two males that are interested in buying a house. These are all protected classes. And another way that this might affect you as a real estate professional. Let's just say you get a call from a buyer. This couple, they call you up and they say, yeah, we're really interested in buying a home. Well, they don't give you an area. They give you how much they're qualified to purchase, what their pre-approvals for, how many bedrooms and baths they're looking for, if they want a single story or two-story, if they want a single family home or a condo, whatever. They give you those specifics, but they don't tell you an area. And you take it upon yourself to search areas that you think in your mind that a person of color would want to live. That is a fair housing violation. So you need to be aware of those types of things. If somebody doesn't give you a specific area, and I don't care what color they are, what gender they are, if somebody doesn't give you particular criteria on the area they want to live, then simply give them anything that fits their criteria throughout the city. If somebody tells you they only want to look at properties in this area, then that's the area you provide listing leads or buyer leads to them for, and show them properties for. It sounds pretty simple, and it really is if you want to stay in compliance with this stuff. Just don't assume that because somebody is a particular color, or because there are people of a certain religion that live in a certain area, that's where you should find properties for them at. Listen to your client, do what they want, and you'll be okay. Let's see here. Oh, this is an important one too. Conduct that may not be motivated by discriminatory intent, but could have a discriminatory effect. And this, if you've been in the business, for more than a couple of years, you've probably heard of buyer letters. And we'll talk more about this down the road in our class. But it used to be very common for real estate agents that work with buyers. They're preparing to submit an offer to a listing agent, and they, at our suggestion, we would prepare a letter. We would work with the buyers to prepare a letter that will be handed to the listing agent along with our offer. And it might include photos of this family, or, the husband and wife and their kid, or, whatever it was. And it would be a heartfelt message from them as to why this house would be perfect for them, and to please choose their offer, so on and so forth. And it sounds really simple. And, if you think about it, just, kind of quickly, what's the harm? Well, here's the problem. We've had competitive markets recently, and I know of cases where people were getting 30 offers on a listing. And what happens if every one of those folks, they were submitting offers that were very similar? The only thing that really distinguished those offers, or many of those offers, were the letters and the pictures that came with those letters of the families or the people. And let's just say that some of those people were protected classes. They were, ethnic minorities, or whatever. And the seller maybe was not the most open-minded and kind of a racist, say. Well, by providing those letters to the seller, you give the seller the opportunity to discriminate against some of those buyers. And that's wrong. And it puts, and even if the seller wasn't a racist, what if he's got some subjective biases that just happen to materialize when he's reviewing these offers and he's comparing this one with this one, and he sees a white family here and an African-American family here, and he says he just subconsciously decides to go with the white family. Well, that's a discriminatory action. And so by providing these letters to the listing agent and the seller, you're putting them both at risk for accusations of being discriminatory. And so that that fact, whether it's actual or unconscious bias, is a problem for the seller and for the agents, and certainly for the the buyers trying to get into that house. And so we now recommend that the sellers authorize us not to turn over those buyer letters. And we recommend to agents not to partake in that when you're working with buyers, because it just creates an opportunity for discrimination to happen, or even just allegations of discrimination. The practice itself works. In my own case, the last house I purchased in the Bay Area, we were up, my wife, my son, and I were up against 6 other families. We did not have the highest offer, but we later found out that the estate of this family, the relatives, decided to choose our offer because they liked our family photo, and they thought the idea of helping this little 5-year-old boy or 4-year-old boy get this beautiful house that he wanted, and he signed the letter with us. They thought that was cute, and that helped us get the home. Now, in hindsight, I look at it and I look at the explanations as to why we shouldn't be doing this today, and it makes perfectly good sense. So try to stay away from that. We've already talked about channeling or steering. That's when you're trying to force a prospective buyer or tenant into a particular area or out of a particular area. We want to stay away from that type of stuff. And that's pretty much what I want to cover on the Fair Housing Forum for now. As I said, there'll be a separate class just for that. The next form that's included in this package, and by the way, this was also updated in December of 2021. Zip Forms did a major rewrite, and then they did an additional rewrite to add in some other stuff in June for some of the forms. But this form is affectionately known as the PRBS, Possible Representation of More Than One Buyer or Seller Disclosure and Consent. And this form basically says, look, we work with multiple buyers, multiple sellers. We don't choose which homes our buyers buy, the buyers that we're working with buy. So if they don't choose your home, don't blame us. That's kind of the gist of what the form says. It also goes into an additional explanation of dual agency, which just it's more disclosure. You'll find I'm a very big proponent of rather over disclose and under disclose. So one more explanation of dual agency. And one important thing here that many agents don't realize or understand: offers are not necessarily confidential. Buyers advise that the seller or listing agent may disclose the existence, terms, or conditions of the buyer's offer unless all parties and their agent have signed a written confidentiality agreement. So whether any such information is actually disclosed, that will depend on market conditions and the prevailing practice in that particular community, as well as the listing agent's marketing strategy. But just know that it is not prohibited, except under limited circumstances, for the agent, listing agent, or the seller to disclose the terms of other offers that it's received. And it might be just a strategy to get some competitive bidding going if they decide to do that. But there's nothing wrong with doing so unless all parties have signed a written confidentiality agreement. Let's see. Now we have our wire fraud and electronic funds transfer advisory. If you haven't heard, there is an extraordinary amount of wire fraud going on, and essentially it's very smart criminals that find a way to insert themselves into existing transactions, and they will provide fake bank information in order to get the buyer to wire funds to them, thinking that it's being wired to an escrow company. And this particular form is designed just to help drive through these words of caution to the parties to make sure that they're on the lookout for that. And if they're going to wire money somewhere, or if they're going to wire their bank account information somewhere, they want to make sure that it's going to the people that are supposed to have it. So that's all that is. And this is our residential listing agreement, finally. First of all, let me just say, it doesn't say anywhere here that this is a contract, but a residential listing agreement is an actual contract. What does that mean? It means that it's not a contract between buyer and seller. It's a contract between, in this case, Jim Jones, Jill Jones as the sellers, and Keller Williams Realty, Sacramento Metro as the broker. Contracts have to have certain terms in order to be valid. It has to have the parties, has to have a start date, an end date, an amount, and it has to be signed. From your real estate classes under the statute of frauds, contract for the state, for real estate, anything involving real estate really has to be in writing. And this is one of those situations. And it has to describe the property to be sold. So if you look at this contract, it has the sellers, it has us. What's missing are the starting and ending dates. We'll go back to that in a second. You have the address of the property, and with that address, you also have the parcel number. I recommend you always include a parcel number on your listing agreement, as well as the address. Very important. Coming down here, you have the list price, $500,000. You have terms that the seller and you agree would be applicable to the sale: cash, conventional, FHA, or submit. Now, do you need to list all these types of financing here? No, it would still be a valid listing agreement if you didn't. But just remember, you want to at least have that discussion with your client. If you are walking around the house and you see dry rot all over the place, you probably want to have that conversation and let them know that, gee, unless this is taken care of before it's listed, you probably don't want to advertise in the MLS that you're going to take FHA offers or a VA offer, something like that. Coming back up to here, you notice I don't have dates in here yet. I want to mention that real quickly. In order for this to be a valid legal contract for listing a property, it has to have a start date and it has to have an end date. I say this because sometimes agents will go out to a property and they'll have everything filled out on the form, except they'll leave the starting and ending date blank, and they'll leave the price blank. And sometimes they'll also leave commission blank if they are concerned they're not going to be able to properly negotiate and sell what they're worth. If any of these pieces of data are missing at the time that the seller signs the contract, it's an invalid listing agreement. So you can't just go in afterwards and fill these in when you get back to the office. That doesn't work. That's actually illegal because you're modifying a document that was already signed by your client. So keep that in mind. Don't make that mistake. If you find out later on, after you filled all this stuff in while you were at the house, and you find out later on, oops, I made a mistake on something, you can go ahead and modify it, but have your client initial where you've made that modification. That way, it's obvious that it's on the up and up and everybody was informed and agrees upon it. All right, coming down here, compensation to broker. Okay, so here, seller agrees to pay broker as compensation for services, irrespective of agency relationships. In this case, I put in 5% of the listing price. Or if a purchase agreement is entered into, you could state a fixed dollar amount. I just go 5% of the purchase price for this one. And then it says, and I don't want you to get caught up in this. It says, and there's this big field here. A lot of agents you'll see, especially if you're on the listing side, a lot of agents will put in here some junk fees. Like they'll say, transaction coordination fee of, $250, or legal compliance fee of X, things like that. That's actually a RESPA violation for you to do that. You can't pass on your TC fees or anything like that. What you charge your seller is strictly a commission or a fixed amount right here. You cannot add in anything beyond that for doing your job. TC fee is a cost of doing business that you absorb. Likewise, if you, let's just say you are doing a short sale listing, because those may be coming back, you have a professional negotiator. You cannot add in a negotiation fee that you collect in addition to commission. So just keep that in mind. Now I'm gonna pivot real quickly from the total commission that you as the listing agent charge the seller that is paid at closing down to here, where what we're referencing here is the amount or the portion of that full 5% that you, in this case, are going to advertise in the MLS to pay the buyer's agent. The buyer's agent technically is not paid directly from the seller's proceeds. The buyer's agent is paid from your commission as a cooperating agent that you collect. So you collect, in this case, you're going to collect 5% of the sales price at the close of escrow. And from your 5%, you're going to pay half of that to the buyer's agent. Okay, it's not coming from the seller to the buyer's agent. It's coming from you, the listing agent, to the buyer's agent. Now, quick word of caution on these amounts here, because it's very easy to do, to make this mistake the way it's laid out in MetroList. When you are entering your listing into MetroList, make sure that the amount of commission that you reference in MetroList is this number, the amount going to the buyer's agent, and not this number. Because if you put 5% in this case in MetroList, you will be selling and you'll be marketing, selling, and closing this transaction for your seller for free. Because every cent that you get in commission, if you put 5% in the MLS, that's what they're going to get. And you are contractually obligated through your agreement with MetroList to pay that other agent that amount. So just be careful. I reference this because I know of somebody who has done this in the past. They just mistakenly, there was a Freudian slip and they popped the wrong number into MetroList on that agent's very first transaction that she ever did. So it can happen. All right. How do you get paid? Well, one, you sell the property, you get paid commission for selling the property. So, and that says, if during the listing period, an exception or any extension, broker or cooperating broker, seller, or any other person procures a ready, willing, and able buyer whose offer to purchase the property on any price and terms is accepted by the seller. So what that means is you list this property today, and tomorrow the seller of the property, Mrs. Jones, brings her person that does her nails by to look at the house, and Mrs. Jones talks the nail person gal into buying the house. You've never had any contact with the nail person. You didn't procure that buyer, but that buyer saw this house and decided to buy it. The Jones family at close of escrow owes you commission. Okay, that's why it's called an exclusive right to sell. Secondly, and so when you fill out your listing form, I recommend you put 90 days in this section under 3A2. And this is basically, I call it a protective clause. And what it means is for 90 days after the listing expires, if anybody that has previously seen that property during the listing period decides to come back and buy the property for, as I said, for 90 days after the expiration of the listing period, if they buy the property, the seller still owes you a commission. Now, you got to jump through a little bit of a hoop in order to make this happen. One, at the expiration or end of the listing period, you have to do a form NPB, which is where you list anybody you know of that has previously been shown the house. Doesn't matter if you've shown it to them or if another agent has shown it to them. You can put that person's name on that sheet and present it to the seller at the end of the listing period. Then you are covered if one of those people comes back and decides to buy the property. So that, and just to let you know, in a few decades of doing this stuff, I've never enforced that provision. It's there to use if you so choose and you could prove it, but whether it would be wise to do it, I don't know. I mean, in today's day and age with Yelp and all the social media stuff, it might be a public relations nightmare if you try to do something like that. Also, if without the broker's prior consent in writing, the property is withdrawn from sale, so the seller withdraws it, conveyed, leased, rented, or otherwise transferred or made unmarketable by a voluntary act of the seller during the listing period or an extension, you are technically owed a commission. Now, that would be difficult to enforce. You're probably going to have to end up going to small claims court, things like that, but it is an option that's available. Again, I think public relations wise, it could probably work against you. This is one though that might be applicable, at least to some extent. So if the sale is prevented by a party to the transaction other than the seller, then compensation, i.e. commission, that would otherwise have been earned shall be payable only if and when the seller collects damages by suit, arbitration, settlement, or otherwise, and then an amount equal to the lesser of half of the damages recovered or the above compensation. So what does this mean? I mean, it's got a lot of words in there, and maybe they're a little confusing. The example that I would use to describe this is you list this house, you go through the entire marketing period, you find a buyer for it, you're under contract, the buyer removes all their contingencies. And then you're coming up towards the close date and the buyer suddenly cancels. Does this ever happen? Oh yeah, it happens pretty frequently actually. So when that happens, your natural inclination as a listing agent and the seller's inclination is to say, whoa, hold on. That's fine. You want to cancel, great, but you need to release your earnest money deposit to me as liquidated damages. Well, what this is saying is that if the seller recovers those liquidated damages, you're basically, as the agent, you're entitled to 1/2 of that recovery. Now, if this were me, if it were my shoes, I would probably forego putting a claim on that. What I might do is have a conversation with the seller, my client, and say, look, here's what the contract says. According to the contract, I should be getting 1/2 of that. However, I'm in the business for the long term. I'm hoping that, that between you and your friends, I'll have clients for life. So what I'd rather do is just extend the listing by a month. You keep all of that, and I will just have a little bit more time to get your house sold for you and get you, where you want to be. I think public relations wise, and in terms of helping build that relationship with your client and maybe get some referrals out of them, it's probably worth a lot more than that. But that's your decision. Now, there's a section here, C, in addition, seller agrees to pay broker. And I put in an example, gardening cost advance for absentee seller. That would be the type of thing that you can get additional money for, but it's not money for selling the house. It's money to reimburse you for expenses that you might have advanced for the client. Whether that be, you're working with a seller who's an out-of-state investor, and during the listing period, you've been paying a gardener to come by once a week and mow the lawn. So you would put that information here, and then prior to close of escrow, you would get those bills to the escrow company so they can cut reimbursement at the close of escrow. That's what you would use this for. Again, we talked about putting the compensation so here's where you're disclosing to the seller in the listing contract how much of your total commission you're going to give to the buyer side. Now, in this particular case, I was charging the seller 5%. I'm offering 2.5% to the buyer's agent. They don't have to be equally split. That's not a hard and fast rule. I've had cases in the past where I have taken less than 2.5% of the 5. I've had cases where I've taken more, where it just depends on the client, depends on how much work it's going to be. I mean, I've always based mine on how much work it's going to be, or I think it's going to be, to work with that seller. If I think the seller is going to be kind of a pain and cause me a lot more work, then I might charge a little bit more in commission and on the amount that I keep on the seller side. But it's, commissions are completely negotiable, and you can divide this up however you want, whatever the market will bear. I would recommend you offer an amount that's going to be sufficient to, compensate a buyer's agent and get that property sold. Let's see here. Quick discussion on MLSs. So most of us here in Sacramento, we use MetroList MLS, Sacramento MetroList. But we also, there are many agents here at KW who show properties or who list properties all over the state. And so MetroList may not be the only MLS system that you're dealing with. So here's the issue. If you're representing a buyer on a property that is listed with MetroList MLS, the agreement that all of us have with MetroList is what guarantees that you're going to get paid your commission at close of escrow. But if you are working with a buyer in an area outside of Metrolist jurisdiction, say one that's covered by another MLS system, my recommendation to you is before you send an offer over to that listing agent, you want to fill out a CBC form. And that's the Cooperating Broker Commission form. I think that's what it's called. Anyway, that form, you want to have that delivered to the listing agent first. It describes your buyers, the who you are, what brokerage you're with, and the listing side signs that, and that's your guarantee that you're going to get paid if this offer is accepted and it closes escrow. Likewise, if you are listing a property in Metrolist and another agent from outside Metrolist jurisdiction submits an offer to you, I would say you want to at least get a CBC form signed, preferably before you get the offer, but at least during escrow. That way there's no disputes as to what the commission should be, how much it should be, what percentage or whatever. It just keeps everything in compliance, which is what we are always looking for. Section D2 over here basically says broker is authorized to cooperate with and compensate brokers operating outside the MLS as per broker's policy. So that's kind of our little safeguard there. Seller hereby irrevocably assigns to broker the above compensation from seller's funds and proceeds in escrow. Broker may submit this agreement as instructions to compensate broker pursuant to 3A. Bottom line is we almost never have to give a copy of our listing agreement. Usually escrow demands are sufficient. I would imagine if the seller was disputing the amount they owe, that would be the point where the escrow company would be requesting a copy of the listing agreement. Down here, when you talk to your seller, they're representing that they haven't previously listed the property with another broker. And if they have, you want to get that information and put it in here. Reason being is that seller may have an obligation to pay a commission if other buyers that have seen the property previously while it was listed with another broker comes back and decides to buy it. You don't want to get into a procuring cause dispute because that can draw out, well, it can take a long time to resolve, and you could end up losing your commission if somebody makes that claim that the buyer that actually bought the property first discovered the property when they were taking that buyer around. So that's why you have these sections right here. Also, this section right here, seller warns that seller has no obligation to pay compensation to any other broker regarding the property unless the property is transferred to any of the following individuals or entities. So again, this is where you can fill those in, or you can refer to an NPV that you attach to this form. Going on to the next page. When you talk to your seller and you're determining what's going to be coming with, or what's going with the sale, what's staying behind, keep in mind as a general rule, if it is not attached to the property, it's not part of the real property. So, a lot of times in the old days, everybody always used to assume that a stove, whether freestanding or built-in, was included with the property. Well, then some smart folks finally realized that a freestanding stove is actually personal property, and they started taking those with them. So the contract started to be modified, and now in purchase agreements, you can specifically note that the stove, the freestanding stove, is being included in the purchase price, along with any other personal property that might be included or that the buyer is asking to be included. But here, for purposes of the listing agreement, we have a spot where, and this is between you and the seller. This has nothing to do with an actual contract. So if the seller tells you here that the fountain feature in the backyard is to be excluded from the sale. And the freestanding stove, the refrigerator, the washer and dryer are to be included. You want to make sure that when you start receiving offers, if and mind you, you're going to put this information in the MLS comments, in the confidential information. You're going to say, in this case, fountain feature in backyard is not included. However, freestanding stove, refrigerator, washer, and dryer will transfer with the property at no value, something along those lines. That way, when an offer is sent over to you, if it doesn't have this information written into the contract, you want to make sure that as a representative of the seller, that you do a counter offer to make sure this is part of the contract, because this is what the seller expressed to you when you took the listing. If you don't get it into the contract, then you're going to have a dispute with the seller, especially if the buyer says, I'm not letting you have that the fountain feature in the backyard. Or if the buyer says, get that refrigerator, washer, and dryer off my property, I brought my own. You don't want to get in, you don't want to get in between that dispute. All right. Leased or not owned items and liened items. This is a really important topic in today's day and age. And the reason is primarily because of things like solar systems. So keep in mind, if you're a homeowner, you can't go without, if you watch any TV at all, you'll see advertisements for solar companies daily, probably multiple times per day. Well, when you get a solar system, there's a couple different ways you can do it. You can lease the solar system, in which case, if you sell a home with a leased solar system, usually there has to be a provision in the contract where the buyer agrees to assume payments on that lease. And then there's a whole process usually where the solar finance company has to approve the new buyer on the lease. And so that has to be dealt with in the contract negotiation process. Likewise, the other option would be that the seller of the home has purchased a solar system. However, when you purchase a solar system, sometimes you might purchase it outright, just pay all the cash and you own it, which is great. Sometimes you might purchase it and finance it, much like people finance a car. If you finance a solar system, though, the typical method of doing so is they do what's called a PACE loan. And a PACE loan for financing a solar system or improvements to windows and doors or an HVAC system, things like that. PACE loan attaches to the title of the home. What that means to you is if you're going to list a home and you know that there is a PACE loan on title, you are probably not going to want to advertise or consider accepting a buyer who's going to be using FHA or VA financing. Because if you're a buyer using FHA or VA financing, they will not loan on a home with a PACE loan unless the seller agrees to pay off that PACE loan at close of escrow. So keep in mind, you don't need to have all the details on the tip of your mind, but if you run across this situation, then you need to come to your coach, come to me. We can chat about it and figure out the best solution for resolving the problem. The next section, section 5, describes what an MLS is and what information is going to go to the MLS and what MLS we use. As I said, our primary MLS is Metrolist MLS, and they're one of the biggest in the state, and they seem to be gobbling up a lot of the smaller ones as we go, which is good for us because we get better access. Section 6 is really, really important. And the reason I say that is because a lot of agents, um, even today, they still like to do what we call pocket listings. And what that means is an agent will go out and they'll list the property, but they won't advertise. They talk the seller into not putting the property in the MLS, and instead their pitch or their spiel seems to be something along the lines of, look, I'm going to list your property and I've got this whole big list of investors and private buyers, and I'm going to find you a buyer on one of those. And then if we don't sell the property in X number of days, then we'll put it into the MLS. Well, what's really happening here under most circumstances, and I'm not going to make it an absolute, there are some buyers that don't want people knowing their house is being, or some sellers that don't want people knowing their house is being listed for certain confidentiality reasons. Maybe it's a divorce situation or something. They want to keep the information pool down as small as possible. But for the most part, agents do this because essentially they're trying to double end the deal. And that's all well and good if they can get the same price for that seller that they would get by offering the property out on the open market. The problem is the best exposure you're going to get for a client's property is by putting it in the MLS, because once it's in the MLS, it's going to syndicate to Realtor.com, it'll syndicate to Zillow, and it'll keep on syndicating out until, and you ever want to do a funny little experiment, list a property and then 2 or 3 weeks later, go into Google and Google that property's address and see how many websites that property address will show up in. That is the beauty of entering a property into the MLS and having it just syndicate out all over the world. And by doing so, you generate competition or potential for competition for that property because you have more than one buyer that you're trying to peg it to. And so instead of just, again, working only for the agent's interest, which should never be the case, the agent is actually putting that property out for everyone, and that benefits the seller, which is what your fiduciary duty requires. So this particular section of the listing form talks about the exposure to buyers through the MLS, why it's beneficial to use the MLS, and how it can harm you, the seller, if you exclude it from the MLS by reducing exposure, so on and so forth. It requires the seller's initial it and the broker or agent's initial here. So that's what this is all about. Public marketing of property. Something that you should pay attention to here is on every listing form, you should always put an X under 7A, MLS rules require or do not require. Our MLS does not participate in the clear cooperation policy. And I'm not going to go into too much detail on this. What I will say is that the clear cooperation policy was thought of, I believe, by NAR, and they tried to get most of the MLS systems to adopt it. Well, at the time that this came out, a gentleman named Dave Tanner was the CEO of SAR. He's also on the Metrolist board, and he's also a real estate attorney and broker. And he had the brilliant thought, and it turned out to be true, that any MLSs that adopted clear cooperation would end up being involved in endless lawsuits, class action suits, for years and years to come. And as it turns out, Dave was 100% correct. And some of those suits are still going on to this day. So Metrolist did not participate or opt to participate with clear cooperation. And in that regard, you need to put an X here under 7A, as well as 7F. You're going to put clear cooperation policy does not apply. Now, in the area in between this, 7B is inapplicable. You can put a coming soon on a property on a signpost or in a window. However, our MetroList rules require that if you're going to market the property, and that is considered marketing the property, you have to, you can't do that any sooner than 3 days before it hits the MLS as an active listing. So keep that in mind. Let's see here. If the seller instructs you not to market the property to the public, that's that rare circumstance that I talked about earlier, seller understands that no public marketing will occur, and the scope of marketing that will occur will consist only of direct one-on-one promotion between the brokers and licensees affiliated with the listing brokerage and their respective clients. Now, as an agent, you also have to submit a MetroList waiver form signed by the seller to exclude that marketing. 8, MLS data on the internet. This basically is just confirming the obvious, that unless you are advised by the client not to put it in the MLS, the MLS rules allow the data to be made available to additional internet sites. In other words, they get syndicated. Part of that is generally, unless we are instructed not to display the property or the property address on the internet, and that's done through this CAR form, SELI, the seller understands that if they do opt out, that their address won't be displayed. So that's not a good thing. You want full marketing to occur. Pictures, addresses. You know, the more pictures, apparently, the more the properties, the listings will show up at a higher level in the searches, things like that. You also, let's see here. So when you get down to item 9 here, seller representations, this is, you know, it's kind of an offensive statement, I guess one might call it, because, you know, basically it's you're telling the seller that they're representing that they're not being foreclosed on, they aren't behind on their loan, they haven't filed bankruptcy or planning on filing bankruptcy, they're not being sued, the government's not investigating them, you know, all of these negative things. And the problem is, if you just go through it and you say to them, well, you know, you're not being foreclosed on, are you, and things like that, if they don't understand the reason you're asking these questions, they may be less inclined to be truthful. And the problem with that won't be a problem on the day you do the listing, but once you get the property under contract and you go into escrow, it becomes a problem. Because if, let's just use a couple of examples. If the IRS has a tax lien against the seller, that might encumber the property. So in other words, the IRS puts a tax lien on the property, seller can't sell it unless the lien is paid or unless the IRS releases the tax lien. If the seller has filed bankruptcy or is contemplating bankruptcy, the bankruptcy trustee will have a claim on any equity in the house, which again would kill your sale. If they're being sued, the plaintiff in the suit may file a lis pendens and tie up the title to the home. Again, can't be sold. If they're being foreclosed on because they're behind on their payments, They may not be able to sell it for enough to pay the accrued trustees fees and any advances that their lenders had to pay because they weren't, the seller wasn't paying property taxes or insurance on the home. So my recommendation to you is to more or less tell them why it's important that you're going to ask these questions, or go through this paragraph, and then just read this verbatim to the client, because once they understand the reasoning behind it, they will be less inclined to try to conceal some of this negative or perceived negative information about their financial state. Broker and seller's duties talks about your duty to exercise reasonable effort and due diligence to get the property sold. Let's see. And presentation of offers. And this is really important, not only because it's part of your job as a real estate professional, but it's required under California law. Any offer that comes in on that property, you absolutely must present that to the seller. You cannot conceal it from them. You cannot pretend that it never came in. I will tell you for a fact, I know of one agent who lost his license because he did not present all offers. And in his particular case, he did not present all offers because he had a buyer he also wanted to represent, and he wanted to double end the deal. So he concealed another offer that had come in, which was actually a better offer. I know of other agents who are currently under investigation for failing to submit all offers to the seller. So, and by the way, just because the seller has already accepted an offer does not relieve you of the responsibility to present a new offer that may have been emailed to you. But let me tell you this, in that circumstance, once the seller accepts an offer, as I said, you still have to present to them any new offers that come in. But the one difference is, if you're already under contract, you need to, and I would suggest you do this in writing. You can do it via email as well as mention it to them face to face. But you need to highly recommend that if that seller is, dead set against, or dead set on accepting that new offer that came in that might be a little better than the one they've already accepted, if they choose to do that, you must recommend that they immediately speak to a real estate attorney licensed in California that can explain to them the dangers of doing that. You cannot explain to them that if you're already under contract to sell the property, you can't sell it to two people and you can't get out of that first deal. You don't want to get into a position where you're practicing law. You just need to explain to them that there are severe ramifications to trying to accept a second offer. And before he does so, or she does so, you need to speak to a real estate attorney. And that's about as far as you can take that. And then we talk here, remember we talked a little bit earlier when we were going through fair housing, we talked about buyer supplemental offer letters. Well, I'm not going to go into them once again with you what they are, but here on this newest version of the listing agreement is where after you've explained this to the seller and why the seller should not be reviewing these buyer letters, here is what gives, by default, it gives the broker permission, even if they get the buyer letters, not to send them over to the seller to review. And that's the default. And what it says here is you can even, unless the seller checks this box right here under C2B, you are actually allowed to put it in the MLS comments. Please do not send over buyer letters. But if the seller is dead set against, turning these things down and he wants to see them, he would have to check this box here where it says seller instructs broker to present buyer letters. Broker advises seller that one, buyer letters may contain information about protected classes or characteristics, and such information should not be used in seller's decision of whether to accept, reject, or counter a buyer's offer. And two, if seller relies on buyer letters, seller is acting against broker's advice and should seek the advice of counsel before doing so. So this is your safeguard. But like I said, the default is you're being told that you should not present those letters. All right. Let's see here. Investigations and reports. This is kind of an important one, and it's important for the most part because of the homeowners association documents section. Once you get an offer accepted, you have a very limited period of time, just days, before, as a seller, you're required to get your disclosures over to the buyer side for review. What this says here is on the listing end of it, the seller agrees within 5 days or some other period of the beginning of the agreement to at least order these various inspections or reports. Now, going through these things, a natural hazard disclosure report, you can basically get one of those, oftentimes within a day of ordering it. It's pretty quick once you get under contract. Most oftentimes, sellers do not do pre-listing inspections in this area, although the trend has gotten more popular of late. But if the seller, if you, as part of your marketing strategy, wish to do pre-listing inspections, then you would want to have the seller order them ahead of time. That way you are ready to provide them with all the rest of your disclosures once you get under contract. The big one that concerns me is the homeowners association documents if the home you're listing is controlled by a homeowners association. The reason this one concerns me, and I always recommend, when these are applicable, I always recommend to the seller to order those immediately. Contact the HOA management company, pay whatever fee they charge to get these documents ordered right away. Because under California law, the management company can take up to 10 days to provide them. Well, let's just say you have to provide your seller disclosures 3 days, within 3 days of acceptance of the contract, or in 5 days, whatever the day period is, if it takes 10 days to get these documents, you're going to be in breach and go over that period of time right from the get-go. So there's an HOA, order the documents, have the seller order the documents right away. Let's see. The seller further agrees to indemnify, defend, and hold broker harmless from claims, disputes, litigation, judgment, blah, blah, blah. If any material facts that the seller knows but fails to disclose, including dangerous or hidden conditions of the property. Basically, if the seller lies and doesn't disclose certain things about the property that the buyer would consider material, and the buyer sues, then there's a hold harmless agreement here. On that note, when you sit down with your seller and you're getting ready to have them start going through their disclosures that they have to fill out, it is extremely important that you have, this heart-to-heart chat with them before they fill them out and say, listen, every home has little problems that maybe you don't think is a big deal, but somebody else might. It doesn't matter what the problem is. You need to make sure if you think there is any chance at all that this could be considered a negative trait to the property or a potential problem to somebody else, you need to make note of it and cover it somehow, somewhere within your disclosures. The last thing in the world you want is for a deal to go under contract, close escrow, and then after the fact, you find out, or the buyer finds out, oh, wait a second, there was a water leakage problem during the winter under the front windows, and we never disclosed, and the sellers never disclosed it, something like that. That's the kind of stuff that leads to lawsuits, litigation, spending lots of time meeting with attorneys, going into court, and bottom line, costing money. So just make sure you emphasize the importance of this to the sellers, of them being as honest as possible, disclosing everything they know about the property. That will solve a lot of problems right from the get-go. Let's see. One more time, the seller acknowledges receipt of the agency disclosure form. Let's see, talks about possible dual agency depending on who finds the buyer. Coming down to D, potentially competing sellers and buyers. Seller understands that buyer may have or obtain listings on other properties, and that buyers may consider and make offers on those other properties instead of this property. And that's also covered, remember, in the possible representation of more than one buyer or seller disclosure and consent form. Security insurance showing audio and video, along with photographs and internet advertising. The way I explain these to the client when I'm listing a property is I like to say, look, based on the marketing plan that I have in mind that we put together, your house is going to be on thousands of internet sites. Every room is going to be exposed to the public. Everyone's going to see what you have on your walls. If you're concerned about anything showing up like that, you want to take it down now, put it in a closet, relocate it to a different house, somebody else's house or whatever temporarily. Likewise, people will be coming through your home to look at it. So anything you have laying around of a personal nature, bank statements, tax returns, checkbooks, if you keep firearms in the house, put those in a safe. Jewelry, put it in a safe or store it with somebody else temporarily. You don't want any financial information. You don't want anybody, stealing your identity based on stuff they find in the house. We do everything we can to try to prevent this stuff. We will put an electronic lockbox on the property. It tracks the agents that go in, the date and time they go in, but we will not always have eyes in the house with those agents and their clients. So you just want to, take every precaution. And I always tell them, I have never had a client in thousands of transactions. I've never had clients tell me that somebody has stolen something from my house. But likewise, I don't want you to be the first either. All right, enough of that. And then coming down to tenant occupied properties. Okay, so if you're representing a seller that has a tenant occupied property that he or she wants you to sell, my first recommendation is don't. I know that's kind of maybe it's a surprising response, but I will tell you that when there is a tenant still in a property and you're trying to sell the property, 99% of the time that tenant will make it as miserable as possible to try to find a buyer to sell the property. They will keep the house messy. They will have such restrictive showing times that you can never get the property shown, and you can only market it in the MLS as something along the lines of, you can't show it personally, make an offer subject to later inspections, that type of thing. And that will harm the seller because that's going to take its toll on the price that they're going to get for the house. Anytime you have to sell it sight unseen. My advice to the seller is counsel them to get the tenant out first, give them notice, get them out of the property, and then we'll market it, and we'll be able to use our full marketing tools, whether that is staging the property if necessary, or just getting it cleaned up so that it doesn't look like a pigsty, and force them to take a lesser or subpar offer. But if they insist on marketing it with a seller in the property, you've got to use this form KLA because the tenants have rights. And keep in mind that a tenancy in California does not just include the four walls of the house or the four boundaries of the house itself. Tenant rights in California, tenancy, includes the boundaries of the lot lines, which means, and it's kind of obvious, you can't even step foot on the lot to put up a for sale sign or put a lockbox on the property unless the tenant gives you permission. Doesn't matter that the seller gives you permission, that right belongs to the tenant. And if you step onto that lot and you don't have permission from the tenant, that's trespassing, both civilly and criminally. So make sure if there's a tenant that's going to be in the property, when you're selling it, you get this form KLA done, and you give the tenant proper notice and all that good stuff. When I'm listing a property, I always try to get the seller to allow a sign, which means I do not check this box here. Most of the offers that you're going to get will come from your, MLS listing. It'll come from social media, maybe. It'll come from other online sites that your property is syndicated out to. But there's also a chance that somebody driving through the area from out of town, going to visit a friend or something, might happen to see a for sale sign. And that might be the one thing that gets your property sold. Plus, it's a nice way of generating business for you, future buyers, future sellers, especially when used right in conjunction with a postcard campaign to the immediate area around the listed property, flyers, handed out door to door around the listed property. That, along with the for sale sign, and obviously the old tools, open houses, things like that. That's good for your business also, as well as for getting the house sold. Equal housing opportunity. We've already talked ad nauseum about fair housing and all that good stuff. Attorney's fees. What this says is, in any action between the seller and broker that arise from this agreement, each are responsible for paying their own attorney's fees and costs, except as otherwise specified in 22A, and we'll talk about that in a second. Let's see here. If you're selling for a trust, you want to check the trust advisory, add CAR form TA here. Let's see. Oh, if the seller intends to include a contingency to purchase a replacement property, so in other words, the seller needs to sell contingent on finding a replacement property, you'd want to check this box here. This listing agreement is great because it has this one little clause here, management approval. And what it says is, within 5 days of executing this agreement, or within 5 days after its execution, if broker or manager of your office doesn't approve the terms, they have a right to cancel. And so the reason this is important is, I said at the onset that this is a contract between the seller and KW. Well, when it's a contract, one side or the other normally cannot unilaterally say, I cancel. I'm done. You can't say, and the classic example here is you can't say to the seller, you know what, you and I, we have personalities that aren't really compatible. Let's just say you have a really difficult seller to work with. You can't say, you and I just, don't have compatible personalities. I think it would be better if you found another real estate agent to work with. I'm canceling. You can't do that. Likewise, the seller can't look at you and say, you know what, I don't think you're holding enough open houses. I'm canceling the listing. Listing contracts do not work that way. It takes two parties to agree to a cancellation. And point of fact, in the case of a listing contract, your brokerage, in this case me, has to also sign the cancellation. That said, paragraph 20, management approval, says that anytime within the first 5 days after execution, if, for example, you discovered that you made a mistake, say on the commission, the way you listed the commissions on this form, and you needed to get that rectified, and say on day 4, you went to the seller and said, hey, I made a mistake here. I'd like to line this out, put this here, and initial it. And the seller says, no, we have a contract. I'm not initialing it. Well, you could then come to me and I can say, well, okay, we're in 5 days after execution. I'm canceling it. I can send a notification out to the seller advising them that per paragraph 20, this listing contract is canceled. That's the primary reason for having something like this. Just if you had made a mistake that was obligating us to something that we didn't want to be obligated to, or if there was another material mistake in the document, we have a little bit of wiggle room here. Dispute resolution, very, very important. Just much like the residential purchase agreement, this paragraph states that the seller and us, the broker, agree to mediate any dispute or claim before we resort to arbitration or going to court. The mediation fee will be divided equally amongst the parties. Just for your information, it's usually, I think, $400 if we use the CAR mediator, plus we pay an additional attorney fee for the mediating attorney. And that's usually somewhere around $250 an hour. There's usually a 3-hour minimum. And usually that's what's necessary to mediate one of these things. So it boils down to roughly $300 or $400 per side that has to be paid to the mediator. What is a mediation? A mediation, really, it's kind of like an umpire. It's usually done by an attorney. Mediator basically looks at the dispute, whatever those disputed facts are, and the mediator will go to the broker and they'll say, well, they're saying this, this, and this. Would you be willing to do this? And he goes to the seller and says, the broker is saying this, this, and this. Good compromise might be this. Would you be willing to do that? And if all parties can come to an agreement, the mediator prepares a negotiated settlement release. Everybody signs it and acts according to that release that was done, whether that's one party pays the other or the other pays the other party, whatever it is. If the parties cannot come to agreement at mediation, then the next step is they can go to arbitration, or if the amount in dispute is less than $10,000, they can go directly to small claims court. Other than that, if the amount in dispute is larger than $10,000, then the only other option is arbitration or regular court action. Arbitration is typically a lot less expensive than court action. Arbitration is similar to mediation, except the arbitrator actually has the authority to hear evidence and make a ruling on how it's going to play out, who's going to do what. It's a lot cheaper than hiring attorneys to go to court, but there's still a cost involved there, but it's much preferable. Let's see, going down here, item 23, I want to just talk about that briefly. This is called a merger clause. Whenever you see in a contract, whether it's a listing agreement, a purchase contract, whether it's a contract to buy a car or to finance it or something like that, whenever you see something that says entire agreement, that's known in legal terms as a merger clause. What does a merger clause do? Basically, it says that what you see here in these X number of pages, that is the entire contract. It's complete and it is an exclusive expression of what we wanted to agree to. And you cannot contradict these documents that are in front of you by presenting any evidence that we made any sort of prior agreement or even an oral agreement at the time we were signing this. So how would that play out? Let's just say you saw in the beginning when we were doing the listing agreement, we put a total of 5% commission. Well, as we're signing the documents, the seller's going through and I'm signing the last page. Right before I sign the last page, the seller says to me, well, I know I agreed to 5%. Would you agree to 4%? And I say, yeah, sure. Why not? But we never changed it on the contract. That would be a contemporaneous oral agreement. But because it's contradicted by the written agreement in this contract, it could not be admitted into evidence and it could not be activated as 4%. That's because it has this statement that says this is the entire agreement. And it falls back on something in contract law that's known as the parole evidence rule. And that's not important to understand other than what I just said here. Ownership, title, and authority. The seller is warranting that they are the owner of the property. There's no other persons or entities that have title to the property, and the seller has authority to execute the agreement and sell the property. If there are any exceptions to that, that's where you would put it here. Let's see, entity sellers. Let's just say the property was owned by an LLC, or it was in a trust, or was owned by a corporation, whatever it is. You can check this, and then you can come down here, and the legally authorized signer is, and you could put their name. And I always recommend you put their title next to it. I don't know if that's actually required. Say they were a trustee or a successor trustee or something like that. But down here, where you sign it, title, you would put trustee, successor trustee. If it's an LLC, you would put member, so on and so forth. And then, of course, you sign it as the listing agent. The real estate broker firm would be, in this case, Keller Williams Sacramento Metro. Let's see here, seller's advisory. And this is one of the last things we're going to cover here. This is kind of the last thing that they're going to really go through before they start completing their statutory or their disclosures that they have to do. So TDS, SPQ, natural hazard disclosure will be ordered, but that'll be part of their disclosures too. Your ABID that you will do will become part of their disclosures. But here, the beauty of this page here is it describes to them in a way, and if you use it correctly, you can give them an idea of the difference between what their disclosure duties are. So when you look here, it first talks about general disclosure duties. And so the way I describe to a client a general disclosure duty is a general disclosure duty is something like, gee, at 2 a.m. on a regular basis, the neighbor behind me has this big dog that's always outside barking. Or, and this is true, at 4 a.m. where I live in Natomas Park, but at 4 a.m., I can hear a freight train crossing Elkhorn Boulevard, Elkhorn Road at about 4 a.m. Typically, it has 88 cars on it. I know I've counted them. It might, you can hear them bumping across the tracks. But at 4 a.m., usually it crosses those tracks, and my house, which is probably 5 miles away, I can hear that train. That would be a general disclosure duty. Or, 3 years ago, we had a mold problem in our upstairs bathroom that had to be professionally remediated, tested and professionally remediated. That's a general disclosure duty. What's the difference between a general disclosure duty and a statutory duty? Well, a statutory disclosure duty are typically ones that are going to appear on a natural hazard disclosure statement. My house is in a high fire severity zone. My house is in an earthquake zone. My house is in a flood zone. I live within X miles of a former military ordnance disposal area. I live within 5 miles of an airport. Those are all statutory disclosure duties. Most of those disclosures will be handled by virtue of simply the seller ordering a natural hazard disclosure report. What's not covered in that report must be also covered in the residential real estate transfer disclosure statement and supplemental disclosure, the SPQ. Why is all this disclosure required? Because for many years now, since 1984, there was a case called Easton v. Strasburger. It was decided by the California Court of Appeals. And that case took real estate purchasing from the old days when property was purchased in a mentality of buyer beware to what we have today, where all homes are sold as is, subject to full disclosure of any known problems or issues by the seller, and the diligent visual inspection completed by both the seller's agent and the buyer's agent. We know those as the agent visual inspection disclosure. The AVID, that disclosure becomes part of the transfer disclosure statement. So if either the TDS is done incompletely or the AVID is not done and presented to the buyer in a timely fashion, the seller's disclosures are incomplete and the agent's disclosures are incomplete. And there can be many sanctions and actions that result from that failure. So the goal here is have the seller make a full disclosure of all general disclosure duties, statutory disclosure duties, anything they know that's defective or even could be considered defective, no matter how remote in that property, as well as the agent completing their diligent visual inspection of the property, things they can see with their own eyes. Doesn't mean the agent has to crawl under the house, crawl into the attic, or climb up on the roof. The agent doesn't have to do that. But anything that's reasonably accessible, walking through the house, any visual observations that the agent can make, they have to write that down. You want that document to be presented to both the seller, the buyer, and the seller's agent if you're on the buy side, or the buyer's agent if you're on the seller side. That all has to happen before the end of the buyer's inspection period. Let's see here. Death and other disclosures. Normally, if somebody has died on the property within the last 3 years, you need to disclose that. The seller needs to disclose that to the buyer. The only exception to that is if the person that died happened to have passed because of HIV or AIDS. There's an exception in California law for that. Condominium, other common interest subdivisions. This would be like HOA documents, things like that for a homeowners association. All that information has to be disclosed to a potential buyer also. Let's see. If the property was built before 1978, lead remediation may be required. And if it is, it has to be done by people that are certified to remediate lead paint. Again, pre-sale inspections considerations. Some people, some agents do like to do pre-marketing, pre-listing inspections. If you do so, though, remember those inspections absolutely must be turned over to any potential buyer. Failure to do so is actually considered fraud if something in those inspections results in harm to that buyer. Let's see here. And privacy notice, nothing there we need to cover. And that is it for this class on the residential listing agreement. Hope you found it useful. I know it's kind of a boring subject. Most of these contracts classes are pretty boring, but it's important to know some of this stuff. Some stuff is less important, but there are some nuggets in there that can really help keep you out of court and help protect your client like you should be doing. So that's it until next time, and I will see you later.